And I'm going to turn the program over today to Bob Jacobs.
Thank you, Ann. And welcome everyone. When Carl and I talked about putting this program together, there was a natural progression, and Carl invited me to talk about COVID-19 and the doctrine of commercial frustration. Conceptually, you have a commercial frustration defense for commercial tenants or others who may be unable to perform their contractual obligations due to COVID-19 considerations. And if those fail, if for whatever reason the defense is unavailable, then the backstop remedy or approach is bankruptcy. So the way that this would normally flow is to talk about commercial frustration first and then talk about bankruptcy. However, as Carl pointed out to me, there is a new homestead exemption provision that becomes operative 1st of next year, and it changes the landscape to some degree about homestead exemption affecting bankruptcy law and what might be available to tenants should their commercial frustration defense not be available. So instead of going first and talking about the commercial frustration and then bankruptcy, Carl is going to present first about the new changes to the homestead exemption. And when he's done, then I'll talk about commercial frustration. So it's to you, Carl.
Thank you. I'm really excited to present today and to present with Bob. And I think that the bankruptcy practitioners in listening when Bob presents about commercial frustration, you can see perhaps in the future a really fun day objecting to proofs of claims based on this common law commercial frustration defense. So hopefully we get to add that to our toolkit. But we got a really splashy law from the state this year after many attempts to revise the bankruptcy homestead. They've finally done it. COVID allowed them to get it through. It's the first revision in over 20 years to the amount of the homestead. So we're going to talk about that. And it has applications both inside and outside of bankruptcy. And as Bob mentioned, a lot of times you can resolve a corporation, but many of the leases that Bob will talk about will require a personal guarantee. And that's where an evaluation of potential bankruptcy defenses to get rid of the personal guarantee may apply. Let's talk about the exemption in bankruptcy though. Now, I know I have a fairly broad audience today. Quite a few of you are bankruptcy practitioners that I know, and then there are quite a few people from elsewhere that practice in other areas, and even some that may be considering getting into bankruptcy. Because of that, you may have a lot of questions. If you know a lot about bankruptcy, some of the beginning here especially might be rudimentary. And so if I go through it too quickly on instinct, please submit a question. Bob will be monitoring the questions as we go along. And that way he can slow me down or ask for elaboration or discussion about any of the topics that require it. First of all, the current California homestead is based on 3 tiers. And it's going to get complicated quicker. But if a homeowner has a home with a lot of equity, the way that we protect it in bankruptcy is we claim that it's exempt, and so creditors can't get at it. Right now, the exemption is either $75,000, $100,000, or $175,000, depending on whether the debtor is married or lives with a minor dependent, or if they have underneath a certain income limit or over a certain age, or are disabled. It gets simple. The new homestead that's effective January 1st instead allows the debtor to exempt at least $300,000 up to $600,000, and anywhere between the $300,000 and $600,000, the exemption is based on the median sale price of a single family home in a prior calendar year for the county where the debtor lives or where the homestead is being claimed. And hopefully those are the same thing. If not, you have a lot of explaining to do, meaning if your debtor claims a homestead in a county where he doesn't live. So you see here, the best homestead we have currently is $175,000, but next year The worst homestead would be 300,000. It's an enormous leap, and for many debtors, it's 6 or even 8 times as high in a new bankruptcy filing starting January 1st. Who can claim a property exemption? Now, exemptions only apply to natural persons, so corporate bankruptcies do not get to claim exemptions. If a corporation's filing, all of the property is subject to liquidation by the bankruptcy court and distribution to creditors, or there's no way to protect certain assets from any of the evaluations of assets to determine a repayment plan in the context of a Chapter 11. Exemptions just don't apply to corporations. The exemptions may be claimed by the judgment debtor or person acting on behalf of the judgment debtor. Basically, this gets a bit complicated, but the person filing bankruptcy, who's a natural person, gets to claim exemptions. In marginal cases where the person may be incompetent and has someone else filing for them, you'll see some ability to claim homesteads from other parties. So I briefly explained the homestead through 2020. We're almost to 2021. So you don't have to learn this if you don't already know it. Just know it gets a lot better with the new homestead exemption starting in January. The interesting thing here is that for the first time, the homestead exemption varies by county. The second is that the law doesn't specify how we determine what the homestead exemption is. I'm sorry, what the median sales price is. You can do a Google search and you can find something that will, well, many different sites that have different statistics. They typically rely on reports, typically from CoreLogic, and I wouldn't be surprised if that becomes the reporter. There's also a Case-Shiller index and some other reports. What I feel will happen in the future is that we'll only rarely have big discrepancies in the difference between the median sales price during the year that we're supposed to anticipate between the different reports. So I doubt that the reporter will be especially important. The bigger deal is that even in Contra Costa County, the reports that I see demonstrate that we should be near or above the $600,000 median sale price, looking at all of 2020. So at that point, determining the median sale price should be quite simple. All the reports may well say it's above 600,000. Therefore, we've maxed out the homestead exemption. San Francisco is above 600,000. Many of the other counties here in the Bay Area are plainly going to be a $600,000 homestead. Second, this homestead exemption average increases every year for inflation. This is a new feature. The old homestead exemption that we just looked at, up to $175,000, was over 20 years old and did not adjust annually. If it had adjusted annually, it would be somewhere around what we're looking at right now. So for the last nearly 20 years, the homestead exemption has been less than probably it was intended to be. And so we're making up for a lot of lost time. The new law takes effect January 1st, 2021, but here's the caveat. The determination of whether property is exempt shall be made by application of the exemption statutes in effect, either at the time the judgment creditor's lien on property was created, or they have language about the series of liens. And the default when you file bankruptcy is that the law will be effective upon as of the date of your bankruptcy filing. So I earmarked this about the time the judgment creditor's lien on the property was created as something that I see could be an issue, and we'll talk more about this later, when it comes to avoiding liens based on their impairment of exemptions. So we'll talk more about that ability inside of bankruptcy. Now, I don't think that this California state law would prevent a January 1st, 2021 filer from claiming the new homestead, but it may grant rights to a judgment creditor to secure property regardless of the homestead and keep its security interest beyond the homestead based on the fact that the judgment lien may have been applied in a prior homestead. Again, just I'll dog-ear this. We're going to talk more about avoiding liens on property in bankruptcy later. Now, this bankruptcy law, the new homestead is encapsulated in 704, which are called the non-bankruptcy exemptions. Real property can be protected from the reach of judgment creditors by recording a homestead declaration. And that homestead declaration is effective against judgment creditors even without filing for bankruptcy. So one doesn't necessarily need to file for bankruptcy in order to benefit from the increased homestead exemption. Homeowners who may be anticipating litigation or severe debt collection practices will want to file a homestead declaration quickly and not delay, so that they can beat any lease pendants or any judgments recorded against the property. They do not necessarily need to file bankruptcy, although the debts may be resolved more quickly through bankruptcy. But there still is a value to the homestead declaration, and the homestead declaration's value has increased now to perhaps $600,000, depending on the county of residence. Within bankruptcy, the homestead is even more powerful because the defense provided by claiming a homestead exemption is paired with the bankruptcy's ability to discharge most of the debt that the debtor owes. So what happens, and this is back to bankruptcy 101 stuff. When a debtor files bankruptcy, an automatic stay is entered by the bankruptcy court. That prevents all collections pretty much against the debtor. There are a few exceptions out there, but if you get into those, you're looking at a more advanced bankruptcy case. So lawsuits generally stop, all collection actions stop, communication stop, etc. Sales of homes also stop. In bankruptcy, a debtor can file and claim a homestead declaration to the amount of soon perhaps $600,000 without filing a declaration of homestead. With few exceptions, a bankruptcy will operate to discharge the debts then that are stayed from collection. So pairing the exemption with the discharge means that the debtor can permanently protect their homestead. California is unique among all of the states in many ways, and in bankruptcy, that's no different. In most states, the states have a choice between accepting a federal scheme of exemptions. Exemptions, again, just to explain the term exemptions. Exemptions are property that cannot be touched by creditors through the bankruptcy process. The federal scheme, so federal bankruptcy law, includes a list of property that can't be touched by creditors. But there's an opt-out provision that says that if states legislate their own list of exemptions, then they can choose to use the federal exemptions, or they can choose not to use the federal exemptions and only use the state exemptions. Now, some states allow people to choose either state exemptions or federal exemptions. California is unique in that we say you can't use federal exemptions, but you can use either one set of California exemptions that are kind of like the federal exemptions, but more generous, or you can use another California unique exemption. This is really important to understand because if you're not especially experienced in bankruptcy law, you'll see a lot of information about exemptions, but you can't necessarily mix the Section 704 exemptions with the 703 exemptions. The general idea is the homestead that we're talking about today comes under the 704 exemptions. We often think of that as the big homestead exemption. There's some other differences between the 704 and the 703 exemptions too, but the homestead is by far the biggest. The 703 exemptions don't protect a homestead, but they grant a fairly generous over $30,000 homestead, wildcard exemption. So 703 will allow you to protect over $30,000 of anything, even cash in the bank. But 30,000 is a whole lot less than 600,000. So the 703 exemptions are less likely to be appropriate for a homeowner who has substantial equity. If you were to file a bankruptcy case for an individual and claim the big homestead and also try to use the 703 wildcard exemption on other property, you would draw immediate objections and the objections would be sustained. You can't use a wildcard plus the big homestead exemption in the same case. So just a heads up to be careful when you're looking at bankruptcy exemptions that you don't cross apply the 703 and 704 exemptions when preparing and counseling a potential bankrupt debtor. Under 703, as I mentioned, there's a generous wildcard exemption, but there's no generous homestead exemption. Also, in order to use section 703, a married debtor has to have, even if they're separated, their spouse sign a form allowing them to use section 703 as well. If you have an individual that's filing for bankruptcy and the spouse is not filing for bankruptcy, you'll want to pay a heads up to this. However, by default, a debtor can use the 704 exemptions, the big homestead exemption. So to use the 704 exemption, the one thing you want to know, they can use it by default. However, if they've signed a waiver for their spouse's bankruptcy and their spouse claimed the 703 exemptions, you want to make sure that that waiver has expired before you assume that the default 704 exemptions exist. So one more time, there's 704 exemption, which is the big homestead exemption. There's a 703 exemption, which allows a big wildcard exemption. If a married debtor wants to file using 703, they need their spouse to waive their right to file 704 exemptions. So before you file a bankruptcy claiming the big homestead for somebody, make sure they've not waived their ability to use 704 when their spouse filed using 703.
Carl, we've got a
Yes.
question. When does the waiver expire?
I believe that the waiver expires at the conclusion of the spouse's bankruptcy case. I have looked into this and don't see any specific language related to that, but there are cases that will drag that will conjoin cases where debtors have filed two separate cases. They have joint cases for joint administration. And then the rule is that the debtors have a limited amount of time to choose which exemption they want to use. But I believe that it is upon the conclusion of the debtor who used 703 exemptions at the closure of their case, then the spouse would be able to file a 704. Under section 704, there's no wild card, as I mentioned, so other personal property may not be protected from sale. If you have substantial home equity and a lot of car equity as well, then you would probably want to talk with an experienced bankruptcy practitioner about what that case might look like. Some of the things that practitioner is likely to think about is doing a reorganization plan instead of a liquidation bankruptcy. So perhaps filing a Chapter 13 or a Chapter 11 bankruptcy so that a bankruptcy trustee can't swoop in and sell all of the cars and other non-exempt assets, even if they can't touch the house. They may also talk with the debtor about pre-bankruptcy planning or exemption planning in order to maximize the amount of property that can be exempted and minimize the amount of property that can't be exempted. We're going to talk more about pre-bankruptcy planning without going too far into the weeds, we'll talk mostly about some of the limits that corral pre-bankruptcy planning. The common phrase when we consider pre-bankruptcy planning is that the pig gets fat and the hog gets slaughtered. So we'll talk about a couple cases and what laws actually surround that and enable hogs to get slaughtered. In order to qualify for a homestead exemption, a debtor must use the property as their domicile or residence. They must be eligible to use California state exemptions, and they must not be barred by the federal, I call them O.J. Simpson rules, because they were passed shortly after Mr. Simpson moved to Florida and bought a mansion with the proceeds from the sale of essentially all of his other assets. And then not have been engaged in other bad acts. We'll go through each of these steps in turn. First of all, residence or domicile. You can't claim a homestead on a place that you don't or haven't lived. There are terms here. Residence isn't defined by the bankruptcy code, but it means basically what you think it means. If you need to get tricky into this, then if you have a tricky case, then start reading case law. I saw a case recently where the debtor moved in a camper and a tent onto some raw land in Nevada to claim a homestead on it, and they qualified that. Mobile homes can be a homestead. Arguably cars, if the individual lives in a car, then the car could be a residence. It could be a campsite, but expect that if you have an unconventional homestead claim, it will be examined by the trustee. So make sure to do your research. Another thing to remember is that in Chapter 7 bankruptcy, a debtor who files needs leave of court in order to dismiss their own bankruptcy case. So when you want to do your research, I mean, do your research before you file the case, especially if you're getting into a Chapter 7 case. We have also this kind of, a homestead can be claimed on a residence or domicile. And there are two different definitions there. Often the residence and domicile will be the same thing. The difference has to do with some place that you left for temporary reasons, but intend to return to. The other catch here is domicile means residence coupled with a present intention to stay there. So, word of the wise, don't let your client have their home listed for sale at the time they file for bankruptcy. If they have a for sale sign and it's on Google Street View, which bankruptcy professionals will often use, get a good explanation from your client as to why they had a for sale sign up in such an obvious place. If the case is pending and they decide to sell their home, their intention to stay there may be questioned. So your debtor may need to show a little bit of patience if while filing bankruptcy in order to convince everybody that the homestead is their domicile. Next, in order to claim California's homestead exemption, you need to be eligible to use California exemptions. Now, this should be much simpler than it is, but where I just kind of glossed over residence and domicile because most of the people you ever speak with will have obvious claims that they live there as their primary residence, etc. The same is not the case for eligibility to use California's exemptions. To use a California exemption, a debtor must have been domiciled in California for the last 2 years before filing the bankruptcy case. So if they've only lived in California for 2 years, you're set to use California law. If they've lived anywhere else within the last 2 years without keeping a California domicile, then you scrap the fact that they've lived in California for the last 2 years, or for most of the last 2 years, or 23 of the last 24 months. That doesn't matter anymore. If they've been domiciled in multiple states during the last 2 years, then you need to look at where they lived for the longest period during the half year between 2 and 2.5 years ago. So you start 2 years back and you look at the 6 months between 2 years back and 2.5 years back. And then you determine during that period which state they lived in for the longest. Now, this is interesting because if your debtor lived in California for 4 months, 2.5 years ago to 2 years ago and 2 months ago, and then moved back to California last week, we're going to have jurisdictional issues, but they would be able to claim California homestead and use California laws. Okay. So in that case that I just shared, you've got somebody who lived for 2 years and 1 month in some other state, but they lived 5 months, the most recent month, and then 4 months, over 2 years ago, and they're eligible to use California law. And they'd be eligible to use California law even if they lived in a different state where they filed their bankruptcy case. So that's a bit of a head scratcher. Be aware of the issue and look out for it. And especially if you're claiming a $600,000 homestead exemption, which exceeds the homestead exemption of most states, be sure that you can claim it under California law. Okay, now the O.J. Simpson rule. So these are limits. We're going to go over a series of laws that limit the application of the homestead exemption. Note that these are all federal limits and they're encapsulated in federal bankruptcy law. These are not anywhere in California state laws. So I would argue that they don't apply to a state declaration of homestead that's filed with the county recorder in order to prevent collection outside of bankruptcy. The first rule says that a debtor may not exempt more than $170,350 in a residence acquired by the debtor within 1,215 days before filing, unless the debtor is a family farmer or transferred the equity from a prior principal residence within the same state the debtor acquired more than 1,215 days ago. Okay, so let's unpack this real quick. First of all, you see this $170,000 number. Don't be misled. That is not the same as the current California homestead through December 31st of this year of $175,000. Those have nothing to do with each other. This is a federal law that says that any state exemption, like California's exemption, that seeks to allow California claimants of California exemptions, we talked about that in the last slide, which typically means California residents, from claiming a really big homestead. Federal law prevents you from claiming above this $170,000 figure if you acquired the residence recently. So they're saying Mr. Simpson moving to Florida and then immediately filing bankruptcy, that doesn't cut it. You have to have owned the residence for 1,215, or I shouldn't say own. You should have acquired the residence or another residence that was your primary residence within the same state more than 1,215 days ago. Okay. Or to get around it, you could become a family farmer, I suppose, last minute. Even then, the debtor still can't exempt an amount above $170,350 if the debtor committed securities fraud or a felony that shows the debtor's abusing the bankruptcy code. And note that felony and the felony has to show the debtor's abusing the bankruptcy code, or a really bad tort like killing your wife. You can read exactly the rules on that in section 522Q. So I think we're pretty justified in calling this the O.J. Simpson rule. If you have a bad actor, you want to get into the weeds and look at the securities fraud, the felonies, about abusing the bankruptcy code, et cetera. But there's going to be an exception to it. You ready for it? So even if you killed your wife or got the exempt property within 1,215 days before, which happens to be 1,215 days from now is Sunday, April 7th, 2014. No, it's not 3 years from now. It's 1,215 days, which is about 3 years and 4 months. Use your date calculator, but do not ask me how Congress picked that number. I have no idea.
Carl, I got a question. Is that actually 2024? Because 2014 is 6 years ago in the past. You must mean 2024.
Oh, yes, I'm sorry, 2024. Yes.
Okay.
Thanks. I'll correct the slide. So that's 1,215 days from now. You know what? I'm going to go through the exception there. I skipped a couple slides. I'm sorry. I will get back to it. So I said that there was an exception to this. So even if you killed your wife and got the homestead within 1,215 days, there is a savings clause where you can show, oh, there it is at the bottom, unless the debtor can show the homestead is reasonably necessary for his family's support. So you got on the last 2 lines of this slide, the savings clause. If you want to, just another tip, show that something is reasonably necessary for your family's support, and it has to do with a bankruptcy trustee not getting an enormous commission for selling your client's house. Be sure you prepare that, because that language there, reasonably necessary, when there are hundreds of thousands of dollars at play, what that indicates is you're likely to have a trial in bankruptcy court over what is reasonable, what is necessary, what is family support. You know, going into all of the debtor's information if you want to prove that. Open questions regarding the federal cap. First, does the 1,215-day cap apply to the value of new equity or only the acquisition of title, right? So this is saying that federal cap, now we're in an age where before, under the old California law, the max homestead you could exempt was near the federal cap. So you rarely saw litigation about this in California. However, now we have an exemption that is significantly above the cap. We're going to run into that cap much more frequently. So the question here is, does that apply to new equity? Say you increase your homestead above 175,000. Maybe you sell a rental home. Your debtor sells a rental home, gets $300,000 of gain from that rental home, and pays down their mortgage on their primary residence with that $300,000. Does the federal cap apply to the new equity? Or does the fact that this homestead you just paid $300,000 down to, you've owned it for more than 1,215 days, is that the important issue that says that the cap doesn't apply? I don't believe that there's sufficient case law on that fact. There is this case in the 10th Circuit Bankruptcy Appellate Panel, and that case finds that the acquisition date applies, which I think in most cases would be favorable to us. But you should be aware that there is little conclusive case law on this, and that Bankruptcy Appellate Panel case law is not even binding within its own district. So this could be persuasive, but it's certainly not binding, both because it comes from the 10th Circuit. And even if the 9th Circuit Bankruptcy Appellate Panel found one way or the other, it's not necessarily binding on bankruptcy courts. So this is a big asterisk when you do your pre-bankruptcy planning. Does the 1,215-day cap apply to the value of new equity? The second open question is, does the federal cap apply to the state homestead exemption outside of bankruptcy? And this is something I indicated earlier. I don't think so. The federal cap is encapsulated in Chapter 11 of the United States Code. It refers specifically to bankruptcy. The federal bankruptcy law just wouldn't apply in a state collection action. So I think that the 1,215-day cap and the other exceptions to being able to take a full, robust $600,000 homestead exemption in California, none of those caps apply when you're just dealing with state collection. That's my feeling. If somebody else has some case law that I haven't seen yet, please sound off now. But I think you don't have to worry about all these caps if you're just filing a homestead declaration and then sitting pretty and preventing a judicial sale or execution on the property. Next, the homestead exemption shall be reduced to the extent that such value is attributable to any portion of the property that the debtor disposed of in the last 10 years before the bankruptcy was filed, based on the debtor's basically disposition of property with the intent to hinder, delay, or defraud a creditor. Hinder, delay, or defraud. So there's a 10-year look-back period that will pull value outside of the exemption, pull equity from a home in this context, outside of the exemption, if it can be shown that the debtor took actions with the intent to hinder, delay, or defraud a creditor. Okay. And there's additional language here about the insolvency of the debtor at the time that those actions took place, is I think what the rest of it says. Some cases on this. Generally with the case law that I've read, it has to do with gamblers. Generally, not always though, generally it has to do also with folks that are not listing assets on their bankruptcy petition or not listing transfers that got rid of assets on their bankruptcy petition. So you got these cases where debtors have pulled money out of credit cards with cash advances, sold cars, and applied the the proceeds from the sale to the homestead. Those are the general fact patterns. Now, what's tricky about this is some of those things like selling a car, that's kind of standard bankruptcy planning. That's generally a green light action. If you sell a car that is exempt from collection, and then you pay down, if you sell a car that is not exempt and then you put the equity into a homestead, that's generally kosher. In cases like these though, where those actions are taken very shortly before bankruptcy, are paired with non-disclosure of the transfers, with non-disclosure of other assets, are paired with enormous gambling debts, are paired with withdrawal of cash advances or extraordinary expenditures on credit cards, for instance, to pay for home improvements, not home repairs, but home improvements, remodels, etc. And then you get into a mix where you're going to run into problems under 522.0. And the courts in these cases were all careful to find an intent to hinder, delay, or defraud creditors. But on the next slide, we find that the courts do have to find that intent to hinder, delay, or defraud creditors. So the Supreme Court in 2014 beat down on some judge-made law that impaired the debtors' homesteads, that basically reduced homestead exemptions based on law that was not within the bankruptcy code. So although hinder, delay, or defraud creditors, 10-year look-back period is in the bankruptcy code, that will prevent any equity that resulted from those actions from being exempt. Other things such as fraudulently, in this case, fraudulently recording a fictional lien to show that your home has less equity than it does, that was not an intent to hinder, delay, or defraud any particular creditor. And so the Supreme Court found that the court made law that said that the homestead exemption didn't apply to this debtor was unconstitutional. And only the specific limitations inside the bankruptcy law regulate what will cause a claim of homestead exemption to fail. So your homestead will hold up if it's in the code. If one of those federal exemptions limits it because you committed a felony, defrauded creditors, in the way that are specified in the code, that all applies. But the courts aren't allowed to go maverick and say, it's really unfair, you're being extra dishonest. So for that reason, we're not going to allow you to protect your entire homestead. That didn't fly. Objections to claims of homestead must take place within 30 days. The standing to object is basically, well, it's the trustee or any creditor, or creditor is going to be fairly broadly construed. But if they don't object to the homestead exemption or whatever exemption they find objectionable within 30 days after the meeting of creditors, or within 30 days after the amendment to the debtor's exemptions is claimed, then they lose their right. I spoke briefly about this earlier. The new homestead exemption is at least 300,000, up to 600,000, adjusts annually. And if it's between 300 and 600,000, it's determined by the countywide median sale price of a single family home. There's no official government index. It's unlikely that the reports that people will eventually settle on will be especially varied. We currently have a Kelly Blue Book versus Edmunds Guide dispute every once in a while in the bankruptcy court where those numbers vary severely. But this is a brand new law. It takes place January 1st. So I suppose at some point the case will come forward where there are disparate valuations from two reliable sources, and then we'll get some case law on it. Okay, here's the tricky part, avoiding judgment liens. One of the best things that we do in bankruptcy is getting rid of liens that are fixed to individuals' residences. The way that it works is different for judgment liens and for consensual liens, such as home equity lines of credit, et cetera. Let me just deal with consensual liens first. So the slide deals with judgment liens, but consensual liens such as a home equity line of credit, a second mortgage, et cetera, those liens can only be avoided if the house is actually upside down. The exemptions, such as the homestead exemption that we're talking about today, cannot be used to avoid a consensual lien. Consensual liens are sometimes avoided in bankruptcy, typically in situations where a home value has dropped considerably. That hasn't been the case for many years now in California. But we cannot use the homestead to get rid of a second mortgage or a home equity line of credit or any other consensual lien. Okay. Now, what the homestead is good for is avoiding judgment liens. We call judgment liens that can be avoided in bankruptcy. There's a term of art called impairment of the debtor's exemption. Impairment means that it prevents the debtor from enjoying their full homestead exemption. The way that we calculate that is we look at the amount of equity that the debtor has in their property, ignoring the judgment lien. And then you add to that equity the total value of the debtor's homestead exemption. If there's any equity left, that's the most that a judgment lien can fix in bankruptcy. Okay, so I have an example here. $1 million fair market value on the home. There's a $600,000 mortgage, so we've got $400,000 of equity. Pre-bankruptcy, there's a judgment lien for $300,000 recorded against it. So you look at just those three figures and you say, the debtor right now has $100,000 worth of equity in their house because they'd have to pay off $900,000 of debt in order to sell the house, right? A debtor in bankruptcy could avoid the judgment lien to the extent that it impairs his ability to claim the home exemption. Now, suppose we have a $400,000 median home sale price in the county in the prior year. We could claim $400,000 of the property exempt. $400,000 plus $600,000 is the entire $1 million fair market value of the home. that leaves $0 of equity for the judgment lien. The way that that's done procedurally is by filing a bankruptcy case, and then within the bankruptcy case, the debtor would file a motion demonstrating that there's no equity left over for a judgment lien holder. The court would then issue an order saying that the judgment lien is void and of no more effect against the real property. And then the discharge in the bankruptcy case would eliminate that judgment lien. In order to avoid a lien, the debtor does not need to show that the judgment lien has no equity left in the house. All the debtor needs to show is that some part of the judgment lien is impaired by the equity. So take this example, but reduce the homestead to $350,000. If the homestead was only $350,000, the debtor would file the same motion and would get an order at the end of that motion showing that the judgment lien of $300,000 was reduced to $50,000 because the other $250,000 of the judgment lien impaired the debtor's exemption. So you can either remove a judgment lien or reduce the judgment lien by operation of bankruptcy and filing the motion where the court approves the avoidance. This is just kind of in conclusion, bankruptcy. A nice conceptual way to think about bankruptcy, if you are a litigator, is that bankruptcy is kind of a lawsuit backwards. So if you get the debtor that comes into your office and says, I have this enormous complicated litigation, I can't seem to get out of it. I've been fighting it for 2 years. It goes on and on. I'm out of money. I can't afford to pay it anymore. And I've got nothing. Well, you know what? Bankruptcy cuts to the chase. It starts with the end. It starts with basically the order of examination. The debtor voluntarily discloses all of their assets, and they show up at a hearing where they can be examined by the creditors. After that, creditors get a chance, right, to examine the debtor. And then there are only a few things that are even relevant to be heard by the bankruptcy court. So a complex litigation will mostly be done away with, as the bankruptcy court will only entertain certain causes of action, typically related to the debtor's honesty. If a debtor can show right at the get-go that there's nothing for the creditors, then you can avoid complicated litigation through what might be a much simpler bankruptcy case. So that's the end of my presentation about the homestead. I'm happy to take any questions that you have now, and we can talk about the bankruptcy exemption aspect of it. And when we're done with those questions, maybe for 5 or 10 minutes, then Bob will present about the commercial frustration defense.
All right, I don't see any questions at this point, Carl. So maybe what I'll do is just go ahead with the commercial frustration piece.
Okay.
All right.
Excellent. Well, thank you.
Okay. All right. Thank you, Carl, for that great presentation on, oh, looks like there's a Q&A question. Just a moment. Let me stop. We didn't see that. So Carl, question, does a single family home include a townhouse?
I'm sorry, so I don't have a chapter or case, but I reckon that it would include a townhouse. I think that the shared walls wouldn't be the determining factor, and a townhouse would likely be considered a single family home, but I'm not certain of that.
Okay. Second question, if you sell assets and put them into your home, do you still get the $170,000 exemption if they find against your new homestead?
So this is that I had a slide on it earlier, and there's the 10th Circuit case that's in that slide. It's a 10th Circuit BAP case that says that the $170,000 federal cap on it, the 10th Circuit BAP found that only the acquisition date of the property applied, and that it wasn't the accrual value. Now, I wouldn't stake my clients hundreds of thousands of dollars on a 10th Circuit BAP case necessarily, unless I had a good waiver signed from them. There may be other cases out there. I didn't do full legal research nationwide, but that's definitely an open question from my point of view, Barry. And I know it's an enormous golden question also when it comes to bankruptcy planning.
Okay. Good, thanks, Carl. And if there's further questions, you can put them in the chat. Carl will be monitoring them, and just let me know, Carl, in a few minutes before the end time at 1:30. We can take other questions, or if you want to do them, that's fine too.
Thanks. Now tell us about the commercial frustration.
Okay, thanks a lot, Carl. Great presentation. What I'm going to do is, there's a great line from The Princess Bride where the bishop is marrying them, and Humperdinck finally says, skip to the end. So I'm going to start this program by skipping to the end, and that way we'll cover the most important things, the sum up, and then I'll go back with the detail. So commercial frustration, it wasn't really talked about a lot, or didn't seem to have a lot of broad application before COVID-19. There are reported cases on it. It's a very well-developed doctrine, but the cases come out of World War I, World War II, the Spanish influenza epidemic or pandemic of 1918, and those types of things where there's a really broad social upheaval that affects the ability of people to perform their contracts due to circumstances completely beyond their control. And the concept of commercial frustration is akin to failure of consideration. That's really the best way to think about it. It's not impossibility. It's akin to impossibility, but it's not. When you have a situation of commercial frustration, the parties have the ability to perform the contract. There's just no value in doing so. So all the value is just taken away from one side or the other in their performance. So it's a contract offense. It doesn't apply only to commercial tenancies or only to real property cases. There's reported cases where other situations have come up where the doctrine applies. And what it does is, if the doctrine applies and if it's available, then the party to the contract has the right to terminate the contract without further liability for non-performance to the other party. So it's a very powerful doctrine. In our current situation, where there's these moratoria about evictions, there's just this, it's you can just see it. It's just this mounting financial pressure that, unless the legislature basically comes in and says landlords forego all right to make claims for past due rent or other contracts that might not be being performed right now, there's just this building financial pressure, and someday it's all going to cut loose. And so if people can't do a workout with their landlord or the party on the other side of the contract, then they're going to be talking to Carl and people like Carl about what's our bankruptcy options.
Bob?
Yes.
Do you mind turning on your video?
Is it not on? Oh, just a moment. Thanks, Carl.
Yeah, thanks.
Okay, got it. Thank you. So people are going to have these pent up claims, and at that point, then people might be looking more closely at commercial frustration. But there's a really, really significant time component to this. Before I get to the time component, the concept of commercial frustration is that performance needs to lose value because of some unforeseen, supervening, think intervening event that is unknown and uncontrolled and unforeseen by the parties. So if it's known, if it's foreseen, if it's caused by the parties, and in some situations, if it's contracted for between the parties, then the doctrine is not going to be available. But if it meets those other elements, unknown, unforeseen, not contracted for, not caused by, then if all, and it has to be all or nearly all the value that would flow from the performance of that contract, if that's all lost, then then it's available. So that what I have done is put together really a sum up of the key cases in this area of the law. It's very narrow. And it's narrow, but it's well developed. If you have a commercial frustration situation or one where you think it might be applicable, the best place to really start is in Witkin. There's a great discussion in Witkin's Summary of California Law about commercial frustration. It's not limited to real estate. It's very general, and it gives a really great broad overview of the application and the availability of the doctrine of commercial frustration. If you have a commercial real estate situation, landlord-tenant situation, then you drill down by going to Miller-Starr. And there's a very good discussion on Miller-Starr. It's considerably smaller, more narrow than Witkin, but drills down deeper into landlord-tenant applications or situations. So after this program is done, Ann Wolf will circulate to all the attendees today the slide deck that we'll take a look at today. It's PowerPoint slide deck on commercial frustration. The way the program is put together is virtually all of the detail is included in the PowerPoint presentation. So it's a 90-minute presentation, so we won't get through very much of it today, but you really lose nothing in the translation because it's all right there in the PowerPoint slide deck. I took a look through the cases in the principal presentation this morning. I brought them all current. They're all still good law. Even with this current COVID-19 situation, there's not new law that's overruled some of these cases or disapproved of them. All the cases are still good law. That's in the way the presentation is put together is there's a lot of citations in the presentation. Those are the ones I brought current. At the end, there's a summary of a lot of other cases. I haven't looked at those specifically. And the cases that are cited at the end of the PowerPoint slide deck, it's not exhaustive. It's not every case on commercial frustration. It's really the leading cases. But by the time you shepherdize those cases and look at the annotations on the statutes that are involved in the PowerPoint slide deck, you'll have your arms around the entire area. The key about timing is this. Well, one more item before I get to count timing. In a commercial tenancy context, the way that commercial frustration is available as a defense is if a commercial lease specifies and restricts the use of the premises to the use that's now of no value due to commercial frustration, then and only then is the doctrine available. It has to specify and restrict. If it does that, then if there's no value or essentially no value, then the doctrine is available. So a good example, suppose that a movie theater has been closed for the last 9 months with no relief in sight. And due to pandemic orders by the county health officer, nobody can congregate, or like an Arthur Murray dance studio, something like that. If you literally can't use it, and if your lease specifies you're going to use it for a dance studio, or if the movie lease says you're going to use it for a movie theater, and the governmental orders prevent you from using it, then you have the ability to possess the premises. I mean, you could still go there during the day, and you could have staff be there. You can't have customers come in, or maybe you could store something there. But effectively, the real use and the value is completely eviscerated. And once that happens, then the doctrine is available. But if the lease says, well, you can't use it as a movie theater, but you could use it as a restaurant. And if the orders would allow you to do takeout, then you've got the health orders would allow you to use it for takeout. You've got a real problem because you haven't lost all the value. It's just maybe substantially reduced. And there's this spectrum where substantial reduction is probably not enough unless it's really, really severe. And if it's to the point where it's completely valueless or close, then it applies. The follow-on point on that with timing is that commercial frustration may apply in a commercial landlord-tenant situation. But if the tenant remains in possession of the premises, then even if there's no value, or even if it's even mostly destroyed, the tenant still remains liable for the rent. And that's even if commercial frustration is a given, if that applies. So you can see how that applies to the current situation right now. There are a lot of commercial tenants who are remaining in possession of the premises that maybe have no commercial value, like a movie theater or maybe a nail salon. And so they would very likely be they would qualify for application of the doctrine or the defense of commercial frustration for their lease payments. But if they don't know about that, and if they stay in possession under existing law, they're liable for the rent. And so it just continues to stack up, and it's like kicking the can down the road. It really puts the commercial tenant in a very difficult situation, because if the commercial tenant asserts the defense of commercial frustration and says to the landlord, I'm terminating this lease based on commercial frustration, and I'm vacating, then there's nothing that bars the landlord from saying, hey, it doesn't apply in this situation for whatever reason the landlord wants to assert, and suing the tenant for the entire unpaid amount of the lease, subjecting the tenant to a present lawsuit. And you know, you look at unlawful detainer remedies and damages, and what happens is, when you have an unlawful detainer, the tenant is liable for the full amount of the lease term minus whatever the tenant can show the landlord could have reasonably released the premises for. Well, if you've got a movie theater and it's all built out as a movie theater, or you've got a you know, a dance studio or something that's all built out, and nobody is interested these days in commercial property, then as a practical matter, that tenant is probably not going to be able to show that the landlord could have gone out and released it, which is why it's a you know, it's a commercial frustration situation. So in that, all right, in the unlawful detainer situation, so what that means is, either the tenant has to say, well, you know, I'm going to subject myself potentially to a lawsuit for the entire amount of the lease term, the unexpired lease term, or I'm going to kick the can down the road and stay in possession so that I qualify for this eviction moratoria, but I don't know what's going to happen on the back end. And if I can do a workout with the landlord, fine. Or if the legislature passes some type of statutes or provisions releasing me from this accrued unpaid rent debt, fine. But barring that, they're going to be in a world of hurt, and either they're going to be looking at bankruptcy or some other real severe kind of resolution of this from all this accrued unpaid rent. Very difficult for this tenant, and I'm aware of that having actually happened with a tenant asserting commercial frustration as a defense, notifying the landlord rejecting the assertion of that defense, tenant vacating, and landlord immediately filing suit for the full unpaid amount of the rent. And it's just very, very difficult for a tenant. So this is not for the faint of heart. You really have to look carefully and do the research, get your feet wet in the cases before you can really successfully advise a tenant on this, and advise them, hey, you may well be sued on this, and you may have to resolve this either at mediation or at trial. And you know, what does that look like? So the most secure resolution is a mediation or a workout with the landlord, so that the tenant knows where they're at. They don't have to face the withering expense of a lawsuit, or wait till the end and you know, wait till there's no more eviction protection and all this unpaid rent comes crashing in, and then sort that out at that point in time. I sometimes get people that ask me, because these days I'm a mediator, I'm doing mediation, if I'm seeing any mediations on these cases yet, and my answer is no, I'm not yet. And I don't believe there really is much that's going on, and the reason is I think it's too early. I think that we've still got these eviction moratoria in place. People are pretty much kicking the can down the road. Landlords are waiting to see what's going to happen. They're not suing their tenants for unlawful detainer. They can't. And they're not suing them necessarily for the unpaid rent. I suppose they could, but I think it's too early. But I think maybe in a year or two, and when this COVID situation is under control, assuming that it is at some point, I think there's going to be a lot of demands and a lot of litigation. And at that point, then I think these workouts will happen a lot more. The unfortunate point is, you just know that a lot of these tenants who are struggling are not going to feel like they have money to go see a lawyer. And not every lawyer is going to be up to speed on the defense of commercial frustration because it's so narrow. And if they don't know about this defense, they may just put themselves in a situation where they have no realistic ability to avail themselves of the commercial frustration defense because they didn't vacate the premises. That is the short course and kind of the summary of the take-home message of this presentation. Having said that, there's a fair amount to talk about that kind of leads up to that. And this slide deck goes through both the statutes that apply, the cases that apply. It gives really good case examples. And what I'll do now, this presentation is scheduled to go until 1:30. So we've got about 20 minutes. I'm just going to start in on this slide deck and go for as long as this will take us. And because I'll just go until we're out of time, I'm going to invite any questions as we go along. Normally, I'd invite people to wait till the end for questions because they may be answered later in the presentation, but we may not get to that point. So if there's questions, please put them in chat. I'll invite Carl to interrupt me and let me know, and I'll take questions as best I can as we proceed. So here is the slide deck. And this is the beginning point. The contract in its inception, the first part of this presentation, just as a kind of a look down the road kind of arrangement, it's talks about impossibility and draws the distinction between impossibility, force majeure, and commercial frustration. So this quote here is the starting point. A contract in its inception must possess the essentials of having competent parties, a legal object, and a sufficient consideration. Lacking any one of these, no binding obligations result. Hence, a contract which contemplates the doing of a thing which is unlawful at the time of the making thereof is void. No surprise there. That's very intuitive kind of hornbook law. For the same reason that you have to have those three elements as in the previous slide, lawful consideration, competent parties. For the same reason, a contract that contemplates the doing of a thing, at first unlawful, but which afterward and during the running of the contract term becomes unlawful, is affected in the same way and ceases to be operative upon the taking effect of a prohibitory law. This is dead on with our current situation with commercial frustration. There's all these leases in place and everything was lawful at the time they were entered into. But once these health orders come into effect, which force people to be at home, and so it's kind of two pieces. The operators or the tenants may not even be able to be present on their premises to conduct business, and all their clientele may be barred from coming in and doing business at their place of business. So that it just seems like an absolute textbook application of this principle as stated in this Goldsmith case. And what you'll see is it comes out in 1922, right around the era of World War I and the Spanish flu pandemic. If performance is not inherently impossible, and there is an unconditional promise to perform, non-performance is a breach where the obligator becomes unable to perform, even though through causes beyond his control, since he might have provided against them in his contract. Okay, so this talks about subjective versus objective inability to perform. And so this first sentence here, if performance is not inherently impossible, in other words, it's not objective impossibility. It's not that nobody could perform it. It's subjective. So if there's an unconditional promise to perform, non-performance is a breach where the obligator is unable to perform since he might have provided against him in his contract. And there's some cases that talk about that. Force majeure law, a contractual provision that allocates the risk if performance becomes impossible or impracticable as a result of an event or an effect the parties could not have anticipated or controlled. Force majeure, it comes from the law French, it means a superior force. And there's a distinction between force majeure and commercial frustration. When you read commercial leases or other contracts that have a force majeure provision, what they say is, here's how we're going to allocate the risk. If something comes up that prevents it, an act of God, strikes, labor shortages, whatever, and here's how that risk will be allocated. As you look at the cases that apply the doctrine of commercial frustration, they uniformly say there is no contract provision between the parties allocating this risk. And so we're going to use these principles of commercial frustration to find out who's going to bear the loss on this. the very strong inference. And then there's cases where the contract doesn't provide for those types of situations, and the courts seem to have a very great willingness to follow those contract provisions. Ergo, if you're negotiating a contract or a lease and you put in there provisions about what happens if we have a pandemic, there's a very real chance that the court's going to honor that, and it may cut across the application or availability of commercial frustration. Impossibility of performance doctrine. That's the principle that a party may be released from a contract on the ground that uncontrollable circumstances have rendered performance impossible. That's different from the force majeure. The force majeure allocates the risk if unforeseen circumstances intervene. This is saying if you can't perform and it's not your fault, then you get released. It's literally an impossibility of performance. Now that's different than commercial frustration. Commercial frustration is an excuse for a party's non-performance because of some unforeseeable and uncontrollable circumstance that sounds a lot like impossibility, but think failure of consideration, not the performance is literally impossible. Impossibility means you can't perform it. So what's the difference between these two? A defense of impossibility must arise in the nature of things. In other words, it must be objectively impossible. Nobody can perform it, and not in an inability of that particular party to perform it. So if somebody contracts, Witkin talks about strict contract liability, and we don't usually talk about that as practitioners. We talk about strict liability in terms of tort, liability without fault. Well, Witkin says, if you sign it, you buy it. You contract to do it. It's strict liability, even without fault. This objective impossibility, we'll take a look at this in just a minute. If performance of a contract is possible, it is nonetheless a breach, although the obligor himself may have become wholly unable to perform. The impossibility must consist in the nature of the thing to be done, not the inability of the party to do it. So if you put yourself in a situation where you can't perform, then there's like a stop. You can't go back and say, oh, I get to excuse myself from this contract because I can't perform because of thus and such, and it's specific to me. No, it has to be objective in order to qualify for both impossibility and for commercial frustration. So here's an example. Where performance depends upon the existence of a given thing, and such existence was assumed as the basis of the agreement, performance is excused to the extent that the thing ceases to exist or turns out to be non-existent. So here's an example. So at the beginning, impossibility only embraced literal or physical impossibility of performance. And there's a couple of case examples that we'll get to in just a minute. Mere unforeseen difficulty or expense does not constitute impossibility and ordinarily will not excuse performance. The same section of Witkin that states that proposition then states, however, impossibility may constitute a defense when performance is impracticable or unreasonably difficult or expensive. Does this sound like double talk? And what's the inference? So the inference really is, if it's just a little more expensive or moderately more expensive, that's not impossibility. If it's way more expensive, that can be impossibility. So it's a factual determination based on degree. A performance may be so difficult and expensive that it is described as impracticable, and enforcement may be denied on the ground of impossibility, even though it would be possible to perform. The enlargement of the meaning of impossibility as a defense, which at common law originally meant literal or physical impossibility of performance, to include impracticability, is now recognized. So here's some examples. A contractor signs a contract to perform work on an existing building, and the building is subsequently destroyed without fault of either contractor or the property owner. What's the effect on the contract? You still have a valid contract. You have promises going back and forth, promises of performance. The building is destroyed. It's literally impossible, so the contract is discharged and neither side is obligated to perform. The owner doesn't have to pay, the builder doesn't have to perform. It's impossible. So here's some more examples. A contract to manufacture goods in a particular factory where the factory is destroyed. Contract is discharged. A contract to ship goods on a specific ship, which is lost at sea. In that situation, contract is discharged. Both sides are excused from performance. So here's a really good case example. So there was a a builder who was going to build a bridge and agreed to take all the necessary gravel for the construction of this concrete bridge from a certain location. And they took all the available gravel, and there was still more gravel needed to construct this bridge. The owner of the property where the gravel was being taken from said, "Well, you got to come take it here." And the builder said, "You're crazy. All the gravel's underwater. It's going to cost me literally 10 times as much money to extract the gravel as I could when I could just harvest it from the surface." And there's a lawsuit on this. The person said, the owner of the property says, "Well, no, here's my contract. You're going to take it all. There's more gravel there. It's not my fault that it's more expensive. I'm going to hold you to this contract." So that, went up on appeal. And the court said in that situation, no, you don't have to do that. Where if the cost was 10 to 12 times more than what you contracted for, even though it's not impossible, it could be done. It's so impractical and so excessively more expensive than what was agreed to. We're going to excuse it from performance based on the grounds of impossibility. This is an interesting case with a software developer who agreed to buy a package of software and then modify it, customize it for their client. This is down in South America, and then provide it. And what happens is they order the software, and then they get ready to customize it, and their customer cancels the order. So the software purchaser who is going to customize it tries to cancel their contract and say, I want to return the software. It's impossible. And the court says, no, both sides are performed. You bought the software. This other side supplied the software. The only thing remaining is for you to pay for it. It's not an impossible situation, and it's not objectively impossible. It's subjectively impossible. It's just your client that canceled. It's not that the nature of the customization is no longer possible. You just lost your incentive because of your customer relations. So that's a good illustration of it has to be objective and not subjective. So here's a good case example. There's a guy named Mitchell. He leased a burglar alarm system from an outfit called FLC. The alarm equipment worked flawlessly. Following installation of the equipment, the United States District Court issued an injunction enjoining any use of that burglar alarm equipment and all other equipment like it because it interfered with secret government radio frequencies. This predates the internet. And the court does not go into any kind of discussion as to just what those secret government radio frequencies are or might be. It just says it interfered with them and enjoined use of the equipment, even though it worked flawlessly. So neither Mitchell, who leased the alarm system, nor FLC, who supplied the system, had any knowledge of this problem when the lease was signed and the equipment was installed. So you see the tension point. They've got this lease, they've got this equipment all installed in place. Mitchell doesn't want to have this long stream of payments because there's no value to Mitchell because they can't use it because of this injunction. FLC is going, hey, we supplied it in good faith, not our fault. We said we had to supply this equipment in perfect working order, and it is. We fully performed, we're entitled to payment. So yes, there's a lawsuit. Mitchell sought to rescind the lease. FLC filed suit for the remaining lease payments, and the lease agreement provided if the equipment is not properly installed, or if it does not operate as represented or warranted by supplier, or if it's unsatisfactory for any reason, the lessee shall make any claims on account thereof solely against the supplier. Now, FLC is not the supplier. FLC owns it and leases it to Mitchell. The supplier or the manufacturer is a third party. And so in the contract between Mitchell and FLC, the parties agreed that if there's any of these claims, if it's not as represented, if it doesn't work, if it's unsatisfactory for any reason, then Mitchell is going to make any claim based on that solely against the supplier and not against the lessor. You're going to still pay the lessor everything that's due under the lease, and you're waiving all claims against the lessor. On the basis of these facts, who wins? This is not impossibility. Both sides can perform. The supplier provides working equipment. Mitchell has the ability to pay. There's nothing impossible about it. It's just whether or not there's value left to the performance of the contract. It's a textbook case of commercial frustration. On the basis of these facts, who wins? Judgment is for Mitchell, the lessee, due to the doctrine of commercial frustration. Neither party was at fault. The lessor had retained title to the equipment. The entire purpose of the lease, which was to provide a working alarm system, was frustrated due to an unanticipated supervening cause. Notwithstanding that very strong language in the lease and the release. Although the doctrines of frustration and impossibility are akin, frustration is not a form of impossibility of performance. It more properly relates to the consideration for performance. Under frustration, performance remains possible, but is excused whenever a fortuitous event supervenes to cause a failure of the consideration. This is a California Supreme Court case out of World War II. Gene Autry, the famous singing cowboy, had a contract to do a bunch of pictures, then entered the military, was overseas, sought to avoid his contract based on commercial frustration. The Supreme Court backed him up. How does force majeure interact with impossibility and commercial frustration? So force majeure clauses are typically a boilerplate or an additional lease clause, and they're often not carefully negotiated. They're just kind of tossed in there just sort of as a matter of course in most situations. These clauses often allocate the risk of loss between the parties in the event a contract cannot be performed because of unforeseen events. And they typically provide an excuse for delayed performance, like maybe if you have a commercial tenancy, the force majeure clause says, well, if the landlord can't deliver possession and all the tenant improvements because of labor, strike, lockout, act of God, whatever, then you're still going to pay the rent, by the way, but the landlord's just excused for performance until they can perform. Labor shortages, war, terrorism, acts of God. Force majeure clauses are recognized by statute. And there's a statute here, 1511. These are very to the point, these statutes. The want of performance of an obligation is excused when it's prevented or delayed by an irresistible superhuman cause. So want of performance, that means breach. So breach of a contract is excused when the performance is prevented or delayed by an irresistible superhuman cause, unless the parties have expressly agreed to the contrary. So that's the statutory basis for saying, yeah, we're going to sidestep the common law application of impossibility when the parties in their contract put together a force majeure clause. We're going to give force to that pursuant to this statute. It's excused unless we agree otherwise. I'm going to pass, just to the shortness of time, I'm going to pass this case example right now.
Hey, Bob, just wanted to let you know it's 1:28 and there's a question in the Q&A for you.
Let's do
I don't
that.
know if you answered that or not.
What's our question, Ann?
It's, will a unilateral force majeure clause, example, benefiting the landlord only, be strictly construed by the court? In other words, is a tenant barred from claiming force majeure under a lease simple because the contract states it applies to the landlord only?
Okay, well, you go back to this 1511, and what it says is you're excused from performance unless the parties contract otherwise. If the contract is oppressive, if it's deemed to be an unreasonable contract of adhesion, if there's not equal bargaining strength, you might have those kind of defenses. But barring those kind of defenses, I have not seen anything in the case law about force majeure and possibility that suggests that even if it just goes one direction, that it's not going to be enforced. So it's not like an attorney's fees clause where it's statutory presumed to apply equally to both parties. It's not like that. So the parties are left to contract what's going to happen if there's non-performance. And there's some case law that kind of talks about that. So I would, in the abstract, I would not think that just because it runs one direction, that it's not going to be enforced. A lot of other interesting cases. We're just kind of at the beginning cusp of this presentation, but like I said, the slide deck, you've seen what the slide deck is like. It's very self-explanatory and it gives full detail. So Ann will send it out, and so you can take a look through it if you've got some force majeure or some commercial frustration cases coming up. We've already talked about the take-home message about that the lease in a real property situation must specify and restrict the use of the premises to what's now going to have no value because of the intervening cause, which might be a governmental order like a pandemic, health order, whatever. Anyway, if you have further questions, feel free to email me. I'm happy to take them up separately, and hope you enjoyed the slide deck. And thanks for being with us. And back to you, Ann.
Thank you, Bob. Can you stop sharing for a second, just so we end this with not a screen? There we go. Thank you both very much. I will be sending out the materials, as Bob and Carl mentioned, probably later this week or early next week. And if you have any questions, please let me know. And let me stop the recording.